Here we go.
Okay, good afternoon. This is the Board of Standards and Appeals Public Review Session for May 10th, 2021, the 2 p.m. session. There is no public testimony during the review session. The first item is SOC calendars, new cases. Item number 16, 10581BZ, 235 Forest Avenue, Staten Island.
Okay, we have proof of service of initial application and of notice of hearing to officials. The proof of initial service was 2 years late, only a month before the hearing notice. I've noticed, because we've had several applications from this particular applicant, that this applicant has a lot of difficulty with giving proper notice. We had another case that was postponed for failure to properly notify. So I'd actually want to spend just a few minutes with him during the hearing to explain how notice works. And then maybe we need actually like a tutorial with the general applicant pool to make sure they properly notify, because we get quite a variety of notice. And it really should only look one way. So anyway, Community Board recommends conditional approval, saying motion to approve for 20 years retroactive to the expiration of the 2012 variance. Any future extension should be limited to 10 years. That's their recommendation. This one was, the waiver was requested under the correct rule 1-07.3B3, Roman numeral 2. I think that was our council picked that up. Proof of continuous use isn't required by our rules for a lapse between 2 and 10 years for some reason, but proof was provided at the project manager's request in the form of utility bills from 2012 to 2020. According to the submission, only the sign and landscaping is out of compliance with the terms of the prior grant, and the sign should be corrected unless commissioners agree that a 30 square foot illuminated sign is permissible. The approved sign was 15 square feet, and that was enlarged from a previously approved sign of 8 square feet. I actually didn't understand what the issue with the landscaping is in terms of that being out of compliance. The site has a residential character, which was a condition of the grant. So the site plan indicates that the sign is non-illuminated, while the zoning calculation page shows that it is illuminated. So which one is it? And those were my comments. Vice Chair Shanda.
Oh, I didn't realize I was,
You were in the
my video was off. I didn't realize that. Okay. Thank you for the clarification regarding the continuous use analysis. Though I found the statement of narrative a little bit confusing to follow with regards to the compliance. I think they need to separate out the compliance chart from the narrative and provide show the compliance in that, because reading of the statement of fact, it's not clear whether they're meeting it or not, and how are they meeting it, and where there's a shortfall, if any. In the statement of fact, okay. So with regards to the hours of operation, it wasn't clear which hours of operation it is complying with. Is it complying with the 1982 hours of operation, or is it the one that has been amended since then? So that clarification would be helpful. They haven't provided a detailed site condition photo, specifically the landscaping details. It's really looking at the site from far away. So I couldn't figure out how much of not in compliance the site is with regards to signage. I agree with you with regards to with regards to landscaping. I agree with you with regards to the signage. Is it a legal, is it a illuminated or non-illuminated sign as is, and which one are they proposing to maintain? And otherwise, from the Google Street View, it seems the site is well maintained. And it is in the context of the neighborhood, though I couldn't quite decipher how well maintained the landscaping is along the lot lines. That's all.
Okay, thank you. Commissioner Otley Brown.
I have no additional comments or questions.
Okay, thanks. Commissioner Sheta.
Thank you, Chair. Nothing additional from me.
Okay, Commissioner Shabeta.
All I have is to add is just a clarification of, I think it said on the statement of facts that this was there was medical offices, but I'm not sure if that, or there's a change because I'm fairly certain there's attorney's offices in this.
This is law, no, it says it's a law firm.
I believe in the statement of facts, it does say office with doctors.
Yeah, it
No,
said,
at the beginning, the building was originally constructed for an office, for a house that had a doctor's office in it.
I see.
And then they got this variance to allow the whole thing to be converted to professional offices, which included doctor's offices, but now it's law offices. That's what I got from the fact.
I know it is law offices to date. I thought that perhaps there was a typo or something along the lines of in the statement of facts, but I'll review it again.
Okay, thank you. All right.
Next item is item 17-27400BZ, 134 East 38th Street, Manhattan.
Okay, we have proof of service of initial application and of notice of hearing to officials. Community board waives its recommendation. This application was before this board for an extension of term in 2019, which term dated back to 2011. So the request is for a 10-year extension from 2021. So this is when a case where we dated it back as opposed to deciding it goes from this time of the hearing or the decision forward. The certificate of occupancy has not yet been obtained, but based on the submission, the only holdup is the fire department inspection of the fire alarm system. The fire department issued a letter of no objection May 6th. Proof of continuous use from the expiration of the time to obtain the certificate of occupancy was provided. The permitted use is use group 6B offices. Oops. Wait a minute, maybe we're confusing. Oh, you know what? Sorry, did I do something wrong?
No, so you skip 6.
Use group 6B offices, and the use here is a law firm, so complies. Am I mixing up two cases where I wrote a note about the wrong one? No, it's the same thing? Okay, just weirdly coincidental. Okay, go ahead. Vice Chair Shanda.
I really have no additional comments on this. I'm fine with this application. Once we have the FDNY, I think we have the sign off. So I don't know, do we need the site inspection to wait on that?
No, fire department said they're going to inspect.
Okay.
Once they say it's on our schedule, then they give us an LNO, and that's the story.
Okay. All right. Thank you.
Sure. Commissioner Otley Brown?
The only thing I want to know is at what time do they think they'll actually have the CFO? That's it.
Mm-hmm. Okay, Commissioner Sheta?
Nothing further from me. Thank you, Chair.
Commissioner Shabeta?
Nothing to add. Thank you, Chair.
Okay, thank you.
Item number 18, 2017-204BZ, 12414 20th Avenue, Queens.
Okay, there are no notice requirements for extensions of time to obtain a CO. The applicant advises that the sewer work by the Department of Design and Construction impedes their progress in relocating the trash enclosure and sidewalk repair. And I checked, there are no open violations, so I didn't have any issues with this. Vice Chair Shanda?
I have no additional comments. Thank you.
Thank you. Commissioner Otley Brown?
I have no additional comments.
Okay. Commissioner Sheta?
No further comments. Thank you.
Commissioner Shabeta?
Nothing further from me, Chair. Thank you.
Thank you.
Appeals calendar, continued hearing items, item number 19, 2018-68A through 2018-90A. This is Santina Drive.
Sorry, I just have a lot of notes. Okay. I want to thank the applicant for being so cooperative on this application. It's been very complicated and there's a lot to go through with it. The updated area study concerning density and lot size, which I thought was quite interesting and well done, reveals an urban planning feature I never realized existed or controls. And that is whether a site is connected to city sewers or provides its own septic system. Here all along, I thought the city planning departments in general evaluated appropriate density and building typologies, determining that certain of those were best suited to an area and to its future growth. And now from this, I learned that planning is instead determined by waste disposal, a rather less glamorous and more basic criteria. And I'd really query whether the city planning, our city planning department is aware of this, that they, determined that it's an R whatever density, but then the waste disposal systems actually determine what the density is. So now actually when you do a flyover of a developed neighborhood, you shouldn't think it's a quote, well-reasoned urban planning principle. Instead, you should think sewage management. I just found that really ironic, potentially sad. My two questions about that reality, though, to the applicant is this. Is or was there an option to build with a septic system versus connecting to city sewers in the examples that were given? The reason I'm asking, and were these planning decisions made by the developer as an option, or were they imposed by the unavailability of access to the city sewers? I ask this in part because the Louise Street development, for example, is a pre-1995 development and is connected to a sewer, where we were told that somehow or other 95 is the magic date at which, up until which you had to provide septic, and then they had sewers. So was that an option? And also the Billou Street building that's mentioned is a post-1995 building and has a septic system. So what I'm trying to understand is, were these options, and is it an option now, so that the density isn't necessarily determined by availability of access to sewers, but a preference for not accessing or a preference for accessing the sewer system? Also, I'd like to understand what is the basis for the position in the study that the larger sites are connected to private septic systems. So there's an assumption that these large sites are large, 10,000 square feet or greater lots, because they had to be connected to a septic system. How do we know they're connected to septic systems? Because that information was not provided in the study. It seems to just be an assumption. The applicant states that only certifications are required from city planning in this application, but one of them is for subdivision approval, which reviews the lot area, lot width, yard setbacks, and bulk requirements, and verifies that they're met. So since that's what we're looking at, we're looking at to see at a certain number of houses fronting on an unmapped street, how do we know that those certain number of houses are acceptable to city planning? Isn't that relevant to those numbers that we're looking at? And so shouldn't we at least have some indication from city planning that the project complies with these things? Normally we want city planning to have decided on these issues first before we finally grant. And so I don't even know, other than us doing our own zoning analysis, which isn't the same as relying on city planning, we don't know for sure that it complies with all of those things. So, and I don't see actually what changes were made to the site plan that accommodates additional parking spaces as we discussed at the last hearing. So we did get a revised site plan, but I didn't see on the BSA site plan what additional parking spaces were provided. The cover letter indicates something was done, but I actually couldn't see that. So that needs to be clearly indicated on the BSA drawings showing the parking lanes, sidewalks, and lighting. And also to explain why the scenario discussed at the last hearing, which provided for off-street parking, wasn't pursued. There's an FDNY approved plan, and that information should be incorporated into the site plan drawing with clear notation. So I didn't figure out what the applicants was referring to or statement of facts until I looked at the fire department plan. So which is a different thing. It's a different agency, right? And I note that rather than providing parking along the western edge of the site of the street, the area now designated for parking could, and I really think should be, a sidewalk or a striped pedestrian route until it can join up with the sidewalk behind lot 60 that should join to the sidewalk in the new development. And I'd like them to clarify that that sidewalk is indeed connecting to the new development sidewalk. I remain concerned that pedestrians from the 21 homes that are proposed, which equals approximately 105 people if you just use an average of 5 persons in a family, not taking into account caregivers and things like that, hired personnel and so on like that, or extended family. So I remain concerned that approximately 105 people, including children, that depend on this portion of Santina have to walk in the middle of the roadway to reach Arbutus. This location, I observe, is a very short walk. It's actually a 15-minute walk to PS5, IS7, St. Joseph High School, and 2 public parks. So people will be walking. I can't imagine that they're going to be driving all the time for 15 minutes away to go to school and to go to a park and so on. And so then that's people with baby carriages, that's little kids on little bicycles and so on, right in the middle of a narrow roadway that's been reduced because there's parking on 2 sides. And even if you look at Arbutus, it has some form of sidewalk or grassy shoulder for pedestrians to walk along. So though the area isn't big on sidewalks, Arbutus has sidewalks. So I would like the owner to attend the hearing so that the owner can be aware of my concerns about the site. The applicant provided the draft homeowners association agreement that was proposed for the original submission that had more units on it. So I think that was 21 2-families. So that HOA needs to be updated to reflect the density that the board ultimately agrees to. It should also include a plan that plots the meets and bounds of Exhibit C, which is known as the quote roadway giving access to the homes on lot 100. And a plan plotting the meets and bounds of the fire egress roadway that runs on lot 77 and 79 should also be provided, because right now it's just meets and bounds, so you actually can't tell where that is. The survey that's provided at Exhibit E to that is completely illegible, and these 2 easements need to be clearly defined roadways. Also, the HOA needs to make clear the access easements for all residents requiring use of Santina Drive and Court. And since I haven't seen that roadway plotted, I don't know if it includes the existing Santina Drive. I actually, I'm not going to sit there and try to figure it out because it starts in the middle of who knows where. This is surveyor language, right? And another issue is, since the owner of lot 60 is the lot that faces Arbutus and along which Santina passes, since the owner of lot 60 has not explicitly agreed to the terms of the revised HOA, and may refuse to participate in the maintenance of a much-used roadway that is essential to access the new development. The two-third majority signatories must obtain and retain full responsibility to maintain the roadway as well as the sidewalks along existing Santina Drive. And just to back up again, the conditions of that HOA and other agreements was that there only needed to be a two-third majority in order to change the terms of the agreement. So that was done intentionally to cut out the lot 60 owner, because the other owners, the other three owners of this property are all the same. They're all the same people. They have different entity names, but they're the same people. So it was a way to eliminate lot 60 from participating in any of their decisions. So therefore, they need to take full responsibility for the maintenance. On the fire department emergency route, the maintenance should also be the responsibility of the two-thirds majority, since there has been no coordinated agreement with other users of Denise Court. This seems to be the only way to assure that that roadway remains open for fire department access. And I'd like our council to review the revised HOA whenever we do receive it. The applicant also states that a performance bond is not required for this GCL 36 action to guarantee completion of the roadway on private property. I don't believe that that's what the language of GCL 36 explicitly states. It states, I'm just going to read the sections that are relevant. The board may, in passing on such appeal, make any reasonable exception and issue the certificate of occupancy subject to conditions that will protect any future street or highway layout. No permit shall be granted for the erection of any building or structure in such city unless the owner has furnished to the Commissioner of Transportation of such city a policy of liability insurance. Every permit issued for the erection of any such building or structure shall contain, unless they do something else, a performance bond naming the city as obligee, approved by such a department, sufficient to cover the full cost of such improvement as estimated by such department. So, and I have to say, this board has seen far too many developments with incomplete or substandard roadways. The insurance and performance bond will ensure that the work is completed in accordance with the approved plans and minimum standards. And those are my comments. I do think we're getting there, but we need to finish these details. Okay, Vice Chair Shanda.
Thank you. The information that has been provided has been very helpful, and I seem to recall there was a vested rights case where the development was again one of those pre-90s building, and one of the tests we had asked the property owner to indicate why it had to be built on this such a large lot, and why there was some analysis they had to provide, and as part of that they had indicated about this whole difference between septic and sewer, and that determined the size of the lots. And I think it had come up with another GCL case also. I was very satisfied with the information that has been provided, and based on Bsa Drawing 10400, I thought the information that's been provided is very helpful. I'm glad that the applicant has agreed to widen the Santina Drive to 34 feet, plus provide a 4-foot wide sidewalk along the north side, and have no parking on the south side of Santina Drive, and having all the necessary notes that FDNY has required. So I really don't have any additional comments. I'm satisfied with the submission that has been made so far, apart from all the legal documents that would be needed with regards to revising the HOA and the restricted deck, etc.
Okay, thank you. Commissioner Otley Brown.
So I analyzed the study from the perspective of the adequacy of road width and accommodating density. And it seemed like between the sewer developments and the septic developments, the access roadway width range overlaps. So based on that, with the Seward lot with actually having a wider range than the septic lot width, but both of them encompass 30 feet in width as a possibility. So therefore, as far as I'm concerned, going from the original 23 two-family homes to 19 single-family homes provides a real reduction in density and intensity of use on those, the private lot, private drive, and so I'm okay with this.
Agreed. Okay, thank you. Commissioner Sheta.
Thank you, Chair. I agree with what was said by Vice Chair and Commissioner Brown. In addition, the only thing I would add is I see that they submitted a drawing with drainage design. I'm talking about drawing number, I don't see actually a number on the drawing, but it is submitted on April 22nd, 2021, and it has all the drainage and sanitary calculations. I would like them to add a note to that all these calcs, including the dry well design, shall be reviewed and approved by DOB. Other than that, I have nothing else to add.
Commissioner Sheta.
Commissioner Shabeta. So I agree with the statements that were made. I do think that this case is, I do appreciate the minimization and the ask. I believe this case is meretricious of GCL 36, primarily because not granting anything would seem like a taking, as I'm not sure if anything could be built here. So I second the statements that are made, and I have nothing further to add.
Thank you.
Madam Chair, do I ask
Yeah.
it now or maybe in the hearing? So now that this new proposal is further evolved, am I resending it to the other agencies? That was a question I had raised.
Oh, yeah. Yeah, you would unless during the hearing something comes up, but yeah.
Okay. Okay, move on, Madam Chair. Ready?
Mhm.
Are you ready?
Yeah.
Okay.
Yeah.
Item number 2018-178A, 2 Oak Tree Way, Staten Island.
Okay, with this one, I understand that the applicant rep is not going to be able to appear at the hearing. That's still the case, right, Tony?
I don't know. He emailed me that he couldn't see the last meeting. Let me email him. He couldn't see the review session, but I told him he was not, his case wasn't in until 2 o'clock.
So so that was the thing, because we could put it on for a, second call, which could even be arguably tomorrow, assuming we had time.
Just like,
But so what I wanted to do is just go through the comments, and we may not be able to hear this today because the applicant
had
can't
an
appear.
emergency this morning.
Yes, so we'll play this by ear. So I'll just read my comments, okay? So we now have city planning, is it city planning? Yeah, city planning authorizations for 3 actions pertaining to the site and actual approved CPC sealed site plan, which is what we want. So the authorizations were for a modification of topographic features on tier 1 sites, a development enlargement or site alteration on a tier 2 site, and a modification of botanic environment and tree preservation and planting requirements. The lay of the roadway on the BSA set last amended on December 2019 and resubmitted recently appears to match the CPC approved set. What I would like though, because it's very confusing in our record when we have a whole collection of drawings and the dates on the drawings are the same. So council doesn't know which is the drawing to use because the drawing dates haven't changed. And maybe they were modified, but the date hasn't changed. So what I would like the applicant to do is simply update the revision date on the drawings being submitted to BSA, just to make it easier for our council to identify the correct set of plans. And in the revision chart, because maybe there were no changes to the drawings, it can be labeled of whatever recent date. So right before the submission, let's say it's submitted in the end of this month, so May X 2021, and then and for the description and the revision, it can say final coordination with January 20th 2021 CPC approved plans or something like that, so that we just know that's the final set of drawings. Because yeah, we're often wandering around not knowing which is the last one. So we're waiting for a restrictive declaration that satisfies fire department and the BSA with respect to cross easement access and maintenance of the shared roadway, and also for the recording of the DEC restrictive deck. And I just want to remind the applicant that the restrictive deck is not ministerial as to the Board of Standards and Appeals. It's a standard requirement for all GCL 36 waivers, where we require cross easements and maintenance commitments for unmapped streets. So it is not ministerial, and it's a BSA requirement, not only a fire department requirement. We also don't yet have DEP sign off in response to DEP's 2018 objection letter. So I'm not sure. Yeah, so originally, if the applicant were attending, the applicant had asked whether we could close this, and I was open to the idea of closing the case if the applicant were present, right? But I don't know whether or not it's okay for us to close when we have an actual objection letter from DEP, and whether we need to keep the case open or whether we could be closed and then wait for that DEP sign off. I know, for instance, there's a percolation test that's holding up DEP sign off, and that test is going to take place in mid-June. So those were my comments. Vice Chair Shanda.
I have nothing further to add.
Vice Chair, Commissioner Ollie Brown.
I have no additional comments.
Okay. Commissioner Sheta.
No additional comments, thank you.
Commissioner Sheta.
No additional comments, Chair. Thank you.
Okay.
Okay, and that concludes the public review session. Whoops, sorry. Go back to the other one. Okay, it's the public review session for May 10th, 2021, 2 p.m. session. SOC calendar, new cases.
Oh, sorry, it's a public hearing. You said
Oh, public
review.
hearing. I said public review session. Hopefully that's okay. Sorry about that. Public hearing, item number 16, 105-81BZ, 235 Forest Avenue, Staten Island.
Yes, good afternoon. Once again, Madam Chair, members of the board.
Good afternoon, Tony.
Okay, the only one in? Mr. Busanelli?
Yes,
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Please state your name again for the record and proceed.
David Busanelli, architect for the owners.
Okay.
Okay.
Have the board's comments?
Yes, I heard the board's comments and I'd like to address them, please. Yes, the proof of filing was late, and that is entirely my fault. I just dropped the ball on that, and my apologies to the board on that.
Okay, so I just want to clarify, because I don't know if you have like 5 or 6 cases that we've been reviewing recently where we've had defective service on almost every one of them. So I'm just going to give you a short tutorial right now.
Sure, okay.
So the
Great.
first rule is, in almost all of your cases, and I would have to say, rather than guess, just do it for all of them. It's better
Sure.
safe than sorry, right?
Yep.
So for all of your cases, within 5, and please counsel, correct me if I've got the number of days wrong. Within 5 days of your submitting to the board, your first application, you must notify what we call officials, right? The community board, your city council member, the borough president, city planning department, okay? You must. Carla, go ahead.
I'm sorry, Madam Chair, it's 3 days.
It's even worse, 3 days. So don't even wait for the 3 days. Just the day you file the application with the board, send copies to those agencies, those officials, okay?
Right.
And don't wait, because if you say, oh, I still have time, then you won't do it, then service will be defective, okay? So
Understood.
the thing, when you send those out, you must have proof of service. So the simplest way to do it is to send those certified mail where you get a little receipt. And the receipts are now available. They have tracking on them. So you can get a copy of the tracking by just going online and putting in the tracking numbers, okay? And
Yep.
so you're getting to us proof of service with those tracking numbers, which are available digitally online, okay?
Right.
So just make that your standard. That's what you do on the same day you submit it to us, right? Okay, and then you send that to submit and you're done. Then you know your service was proper. On the other end, when you get a notice of hearing from us, we submit that to you, right? And
Yes.
if you don't receive it and you know you're calendared like 2 months from now, and you didn't receive a notice from us something like 30 days before the hearing, don't wait. Call up your project manager and say, I never received a notice of hearing. The notice of hearing will have the instructions on what you have to do, but I'd have to say in your case, better safe than sorry, just for any new case. So is this for any new case, most of the time you're doing extensions of terms. So if it's a brand new case that the board has never heard before, you must notify the neighbors, okay? But if it's an extension of term, it's the same officials who get the notice as you sent the original application submission to. And the rule is the same. You must send out copies, the notice of hearing you receive to them, and you must do it certified mail with the return receipts with the tracking number that you must submit to us. Otherwise, we can't hold the hearing. That's the first part, but there's also a publication requirement, right?
Right.
So Carla or Tony, can you just go through the publication requirement?
No, the publication must be done, I believe it's 2-3 weeks before the hearing. And it's, I think it's 2 times that you must do the notice. Oh, thank you, Kurt. Yeah, 1 day of each week for 2 of the 3 weeks before the hearing.
Okay.
Do that. So notice is defective if you haven't done that, okay? That's why in one of your cases, though you served the officials, you didn't publish.
Right.
And that's to delay to delay it, right?
Mhm.
Okay, so and then the other part of it is all of the service of the notice to officials and so on, of the notice of hearing, must be done at least 20 days before the hearing, otherwise it's defective, okay? So again, the second you receive the notice of hearing from us, notify. Don't say, oh, I still have 10 days or something like that. Just do it. And that way you won't have these problems where your service was 5 days short.
Okay, I appreciate that.
Okay. And if you have any other questions on it, much better to call a project manager and ask than to do it wrong and delay your applications, which costs your client money, frankly, and maybe you also, so, okay. All right.
Okay,
so-
thank you very much for that. I understand that the Community Board 1 gave us the conditional approval, requesting only a 10-year renewal, which is completely understandable. The owners dropped the ball on this one. In terms of the landscaping being out of compliance, that would be the required landscaping that was supposed to be on the west lot line with the adjacent neighbor to screen the parking pads. That had been in, and over the years, I guess the shrubs must have died. So they will be restored. And the original request for, and the original spec was for hickeys, hemlocks, et cetera, at 4 feet high at time of planting. So they will be replaced.
So one of the reasons we didn't know is because we don't have any photos that show the edges of the property. So provide those photos.
Sure.
So that,
Yep, duly noted on that. In terms of the sign, it is not illuminated. I see on the sign analysis sheet where it indicates where I filled in illuminated. No, I filled in every box to be sure that it was thorough. I mean, I could delete it and just resubmit it and just make sure it's limited to the non-illuminated only, if
okay.
that's acceptable.
Yes, please. Don't fill in every box if the box is NA.
It's one of those things where I try to be thorough, and I was a little out of practice on this, so it's been a number of years. So in any event, I will correct that. In terms of the narrative and the comment on lack of clarity, on compliances, the only non-compliance really is the sign. It somehow grew from the original approval, and the landscaping. So I can clarify the statement of facts to make it crystal clear. If a table is necessary, I could do a table and illustrating both.
If it's just two, you don't need a table, just make it clear.
Yeah, well,
And then also clarify the occupancy.
right. The occupancy is legal, offices only. Let's see, at a certain point, it was going to be professional offices, but including medical and legal, but now it was late. The last time it was done, it was changed to legal. So I'll clarify that.
But in terms of use groups,
It's
use group 6B is professional offices, so
Right.
it doesn't matter actually. But so you have use group 6B as the allowable use, and then it's currently occupied and has been occupied for the however many decades actually by a law
Right.
firm. Okay.
right,
So
but they had made a distinction. So I'll just clarify it to make it professional offices, use group 6B. So, and to keep it straight. Okay. And let's see, clarify hours of compliance. We are abiding by the most recent resolution. So that will be clarified, that those will be the hours of operation.
Okay.
And in terms of the site photos, we discussed that, just make it crystal clear as to the landscaping. Because the only, I mean, it's grass. The landscaping will be replaced along the west lot line, and in the rear, there's a gabion wall and it's in shade, so really nothing much is going to grow there but shade plants anyway.
Okay.
Okay.
Any questions from commissioners? Anything? Okay, thank you.
Okay,
So
thank
let's
you
go to-
very much.
Thank you. We're going to go to the public and then we'll come back to you, okay?
Okay, the application that we are currently discussing is 105-81BZ, 235 Forest Avenue, Staten Island. And the call-in number is 646-558-8656. The Zoom webinar ID number is 997-3548-2603. And the passcode to be required is 564549. If you wish to speak, you can press *9 to raise your hand to speak and *6 to unmute. And if you're in the Zoom already, please raise your Zoom hand by pressing *9.
Okay. So I would just sort of like to query with commissioners, if I've got this right, this was approved in 1982 for a term of 15 years. So the community board is just concerned that they don't come back on time. I don't personally have a problem with the continuing it as the, oh, okay.
We have a hand up.
Actually, who's raised their hand, Mike Sana.
Oh,
That's
yeah.
just,
Mike, you're in the other case, or are you this one?
Oh, no, I'm sorry. I may have hit prematurely. I'm sorry. I'm going to lower my hand.
Thank
okay,
you.
thank you. Okay. All right, so I don't see anyone else with their hand up in the waiting room, but, okay. So, yeah, so commissioners, I just would like your comments on the term that's requested. I believe, Mr. Businelli, you're asking for a continuation of the 15-year term, is that correct?
Yes, if it is at all within your purview to do that, that'd be great. But I do understand if you reduce it. And I think the owners would understand that also.
Okay. So, yeah, so let's just go around. Vice Chair Shanda?
I'm fine with 15 years because it's from the time of expiration of the last, which is 2012. So already almost 10 years has gone by. So will be 10 years next year. So.
Right, but so that would mean they'd have to come back in 5 years. And one of the things, so the.
Oh, no,
community-
I'm sorry. I meant my math is really bad today. 20 years I would be okay with 20 years, 10 from the time of the time it expired. That takes you to 2022. And then the usual 10-year term that the community board was asking would be continuing from 2022. Is that what you were?
No, but so the original grant was for 15 years. The community board was looking at it in a way that's one way to look at it. You say grant this time for 20 years, but the next time for 10, right? And another way to do it, which we do sometimes when we have what is viewed as let's say a good actor who doesn't have a sort of a noxious use, let's just say, we sometimes don't say that we look back all the way to the last time they applied, but we move it forward so that they don't have to come back again. Is Carlos hand?
Yeah, because isn't it?
Yeah, I just wanted to clarify because I know the project description calls it an extension of term. Technically, this is an amendment to the board's condition of term. So it's
yeah.
completely within the board's discretion, and it's not a statutory requirement of term or how long. It's not guided like an 1141. So I just want to clarify because it's
Okay.
reading as an extension of term, but the term's long gone. So we're
Right.
considering the board's condition of term here.
Right, and which is even possible to eliminate a term then, right?
It's completely within the board's discretion.
Okay, so that's another thing, I'm looking at this and it's use group 6B, which is a very limited typology, right? So it's either law firm or an accounting office or an architecture office or a doctor's office, that kind of thing, right? In a quite a small building. So you could even argue, what does it need a term for? They're not arguing to eliminate the term though. But so I personally would say 15 years to continue the term so that the community board doesn't feel like they're sort of cut out of the process completely. And then, but you started from now as opposed to a look back that's almost 10 years. So that's kind of what I was getting at.
Okay. I'm fine with it.
Okay, Commissioner Ollie Brown?
I'm fine with 15 years from the grant, this grant.
Okay, and Commissioner Sheta?
Thank you, Chair. Same here. I'm fine with 15 years from the current grant.
Okay, great. And Commissioner Shabeta?
Thank you, Chair. 15 years from the grant seems reasonable to me as well.
Okay,
Thank you for that.
sure. I mean, this is what you call a really, classic use in a residential community. It's not a disruptive type of use. So, all right. So let's see, is there anything we can do? Can we close this? Could we close this maybe? Do people have an issue? Yes, so we could close this. You plant your missing shrubs.
Sure.
You fix your illumination situation on the charts, and correct the language in the statement of facts. And then we can vote on it. So if I close this, how much time would you need to plant your shrubs, take pictures of them, make some small corrections on the submission?
Let's see. I would say 3 weeks to give the owners time to get the landscaper in there and do the planting.
Okay.
Just, Mr. Busanelli, just confirm, I know you stated it on the record, but confirming your statement of facts, the hours of operation that you're gonna be held to?
Sure. They were the most recent hours of operation, and they would be, let's see. Just want to make sure I've got the right paragraph here.
I have
8:30 a.m. to 6 p.m. Monday through Friday, 8:30 a.m. to 1 p.m. on Saturday. And that was, oh, I'm sorry. We're going from 9 a.m. to 8 p.m. Monday through Saturday, closed Sunday.
Oh, wait a minute. What did you say?
Right. It was, the original language was to permit a change in the hours of operation from 8:30 a.m. to 6 p.m. Monday through Friday, 8:30 a.m. to 1 p.m. Saturday, and 9 a.m. to 8 p.m. Monday through Saturday.
Okay, please clarify that
Sure.
really clearly, because I'm frankly still confused.
Okay. No, it was very confusing the way the language was written, but I will clarify it.
Yeah, so you don't have to say it'll look just like the previous approval. Just tell us what it is you want now, okay?
Yes.
Don't refer back to the prior approval because that just confuses us. Say
Okay.
what we want now is the following, and that way our council knows what to write in the resolution and won't have to say, can we reopen the hearing because we still don't know the answer.
That's fine.
Okay.
That's fine.
Carlo?
Yeah, Carla, go ahead.
Yeah, hi, Mr. Busanelli. Just,
Carlo.
hi, how are you?
Good.
Yeah, just after the hearing, discuss with your client and confirm with the landscaper the amount of time. We will be reaching out to you in a few days.
Sure.
With the tentative hearing date. Just make sure that will work for you so that we can schedule you accordingly.
Certainly
Right.
will.
Yes, and I actually, when you said 3 weeks, I wrote 4.
Okay.
I
Okay.
know how long it takes to order shrubs that are no longer available. And all of that
Right.
kind of thing. Okay. All right. Thank you very much. So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Artley Brown?
Aye.
Commissioner Shepherd?
Aye.
Commissioner Shabeta?
Aye.
Okay, this application is closed.
Fantastic. Thank you very
Hearing is
much.
closed. Thank you. Item number 17, 27400BZ, 134 East 38th Street, Manhattan.
Okay, we have a few people in the room who's,
Jeremiah is the
Mr.
applicant.
Condrevis is acting on behalf of the applicant.
Good afternoon, Madam Chair and Commissioners. My name is Jeremiah Candreva. I'm attorney for the client. I'm joined by Michael Popek, who is the principal for the applicant. We've attended the review session.
I have to swear you in.
wait. Yeah.
To swear you in, Jeremiah. Raise your right hand. Right hand, sorry. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Mr. Popov? Yes?
You have to say I do on yourself.
Sorry, I do.
Okay, please state your name for the record and proceed, Mr. Candreva.
My name is Jeremiah Candreva. I'm counsel to the applicant. I'm joined by Michael Popek, the principal of the applicant. We attended the review session, and I thank you for your time. I did prepare testimony, but in the interest of time and efficiency, I thought I would answer Commissioner Otley Brown's question with respect to when we anticipate getting a certificate of occupancy. We hope to have that within 3 to 6 months. The application, however, is asked for an additional 12-month period. There were some delays given COVID-19 at the buildings department. They really have improved recently on timing of work and application. We already hired Milrose consultants to update the certificate of occupancy. And so in that regard, we believe we can receive it in 3 to 6 months, but we have asked for additional time of 12-month period.
So additional, so 18 months or a year?
No, just 1 year, Madam Chair.
Okay. All right. Anything else that we needed? But this is actually, oh, extension of time which expired. Okay, got it. All right. Any comments from the board? Okay. So you're sure that a year is enough so that we don't have you back again for another extension of time to obtain a CO? Okay.
Yes, we're reasonably confident now that we have the fire department issue resolved, that we can get the certificate of occupancy within 12 months.
Okay, great. All right, let's go to the public.
So the application we are currently discussing is 27400BZ, 134 East 38th Street, Manhattan. The call-in number is 646-558-8656. The Zoom webinar ID number is 997-3548-2603. And should you require it, the passcode is 564549. You may also, when you call in, press star 9 to raise your hand and star 6 to unmute. If you're in the Zoom room already, please press star 9 to raise your hand to speak.
Okay. So I don't think we have any open issues. So I just want to give it a few, because we have a long delay between YouTube and our actual reality time. So just to give a little bit. And other than that, I don't see anyone in the waiting room. I don't think we had any other issues with this. So seeing no one in the waiting room and no open issues, I'd like to make a motion to close where there's no submission.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheha, Commissioner Shabeha.
Aye.
Okay, this is closed. Thank you.
Madam Chair,
Yeah.
would it be possible to vote this item out today?
We don't ever do close votes. Not since, so just for your information, since the whole Zoom life, it was impossible for us to do a close and a vote. But we've learned something, that since we stopped doing closed votes, our council is able to turn out the resolutions very quickly because
you.
they have that warning. And so rather than waiting weeks and weeks for the resolution as a result of a closed vote, you'll get your resolution very shortly after a decision. So in the end, it's a better method.
Thank you very much. I appreciate it.
Okay. And again, so you know, there's no submission. So I try to put those cases on the very next hearing, assuming that there's nothing, you know, it's not impossible at that hearing. Okay, so probably May 20, what is it, 24th, 22nd, something like that.
The next hearing would be May 24th or 25th.
Right.
Thank you, Chair.
May 24th of this decision. Sorry.
Thank you all.
Item number 18, 2017-204BZ, 124-14 20th Avenue.
Okay. Okay,
I'm
ready?
here.
Hi, go ahead, Tony.
Sure, sorry, I was just emailing someone. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay, please proceed. State your name for the record, Mr. Bonfiglio.
Paul
And-
Bonfiglio. I don't have an image, though.
Okay,
Okay.
Okay,
you can't do it.
you can read your name.
Okay.
All right, is there anything you wanted to
Well, I
say?
heard the review session. I don't know. I guess there wasn't what to say about that. It's just that we are all done, ready to get our C of O, except we need the new resolution showing the a date on there that we're within that period of time.
Right, okay. All right, so let's go to the public.
Okay, the case that we are currently discussing is 2017-204BZ, 124-14 20th Avenue, Queens. Should you wish to call in, it is 646-558-8656. Zoom webinar ID number is 997-3548-2603. The passcode, should you require it, is 564-549. And if you are in this, if you wish to speak, you can press *9 to raise your hand and *6 to unmute to speak. And if you are in the Zoom room, you can press *9 to raise your hand to speak.
And there's 4 people in the Zoom room, but I think all of them affiliated with another case. So, but if you're interested in speaking on this, please raise your Zoom hand.
This case is 2017-204BZ, 124-14 20th Avenue, Queens. We should only be looking to discuss that case.
Okay. So I think we've actually talked about this long enough to have people call in. This was mostly a delay tactic. So I'd like to make, so there's nothing to submit on this. I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda. Vice Chair Chanda.
Not sure what's happening with my thing. Yes, aye.
Okay, sorry. Commissioner Otley Brown,
Aye.
Commissioner Sheha,
Aye.
Commissioner Shabeta.
All right.
Okay, application is closed.
Thank you. I hope you like my background. Did you see it?
It's very
Yes.
interesting.
I'm actually in outer space right now.
Right, we can tell. We all feel that way sometimes.
I'm orbiting the Earth.
So we'll let you know when the decision date is. It's likely going to be May 24th, but we'll let you know because there's no submission required here, okay?
Okay, thank you very much. I appreciate it. Okay,
Okay, good to see you, Paul.
thank you. Same here, Tony.
Appeals calendar, continued hearing items. Item number 19, 2018-68A through 2018-90A, Santina Drive, Staten Island.
Oh, let me get out.
Now, Mr. Santa. Okay, Michael Santa. Do you have your people ready? You're muted.
How's
Yeah.
that?
Okay, you can proceed. There's no swearing in. It's an A case.
Okay, very well. Well, I listened to the executive session and I see that a lot of the commissioners are in agreement with the application and that there are still some questions or issues about the HOA and some of the other documents, which I hopefully can answer right now. I'd like to start with the first question to Madam Chair about the septic system, so I can give you maybe a little more clarification of that. And I think what I wrote in the summary was giving some insight, but I'll go over it pretty quickly. The these sites in this area were mapped on R32 from 1961 to 1999. So that would have permitted any type of residential use, multifamily, garden apartments, semi-detached, 1 or 2 family homes. But because there were no sewers available to connect to, then the requirement goes to the 10,000 square foot, 100-foot frontage, a requirement regardless of the zone. So the septic system usage, which is a DEP requirement, supersedes your ability to realize your zoning potential. And that's question one. And the second component of that is that if you have a sewer that's available for connection, you must connect to it. You don't have the option of, I don't want to connect to the sewer, I'll go to a septic system. Septic is only an option when there are no available sewers. So I hope that answers that particular question. And, you know, it's just interesting to see that in 1999, when city planning decided to change this zone to R3X, which is 1 and 2 family detached, they effectively then created the ability to do what, you know, many of the developments in the area that were built after 1999 had to comply with, as long as they had sewer connection. Now, if they didn't have sewer connection, then they would be relegated to a septic system and the other requirements.
So just to get that straight, so once city planning just changed to an R3X, you could only comply with zoning and therefore make greater density if you could connect to the sewer, and you didn't have a choice. If you could connect to a sewer, you had to connect to the sewer.
That is correct.
If you didn't have a sewer connection, then the overriding principle would be a 10,000 square foot minimum with a septic.
Yes.
However, so my other question is, you could have opted for a 10,000 square foot site, but also connect to the sewer system.
Well, you can always go, I mean, that
Right.
wouldn't really be respective of, you know, any kind of zoning potential. And, you know, anyone who would purchase a property is, you know, under the understanding that they would have the right, provided they had sewers, to be able to develop to the zoning that was established by city planning.
Right, okay. So, but I guess one of my questions is, when you were looking, maybe you're going to answer that question, but I'll just, since I'm here. When you were looking at the sizes of the sites, how did you know that they were septic sites versus sewer sites on the large lots?
By going to the C of O issuance. On the C of O, it indicates on the back of the C of O, what kind of sanitary or stormwater discharge system that the property is under. And it would say septic or private disposal system. And the same would apply for dry wells unless there was the available storm sewer connection.
It actually says that on the back of the old COs or the
Yes,
old-
the new C of Os are a mess. The new
Yeah,
C of Os, they don't really give you property descriptions. The old C of Os, they would, on the back of the C of O would tell you that.
Huh. Now I'm gonna look. I never
Go ahead.
noticed. So no, I don't just mistrust you or anything. I just never knew what that was. So now, what is it that you're actually looking for when you read the back of an old CO? What does it say?
Well, I would say, sanitary disposal system, going to give you options, and there would have to be a box checked, and the same would apply for storm.
Okay. Okay. Thank you. Very interesting. Okay, go ahead.
All right, so hopefully that would answer that particular question. And I did hear all the comments about the HOA, which, as I had indicated in my letter, we need to amend the HOA, because currently now it shows for the 23 2 families in the HOA. That will have to be changed to the 19 1 families. So all of that documentation is necessary once we get the acceptance of this plan. And I have preemptively, at your request is also, it's prudent for me to do the same. I already started some of the processing that I can go for. We went to the Department of Finance and submitted into them for the 19 lots. And as you may or may not be aware, Department of Finance has been having significant problems with getting through their system, whether through COVID. COVID has really played a big part. But fortunately, we've managed to have that reviewed. We paid for it, and we're just waiting for them to send us the actual form. And I'm already established and ready to go to house numbers, which will not be an issue. What I'm trying to do here is, because the numbers are, they're generally, house numbers, has generally sequential in their order, and the same with the lot numbers. Sometimes there's a little variation here or there. So we've already been issued tentative lot numbers. We were issued house numbers. So I'm leaving the house number with the lot number, which matches the BSA calendar number, and the bin in DOB to be representative of a house that's proposed, and literally dropping off 4, 2 at the top, 2 at the bottom, so that it makes for an easy paperwork transition for everyone. So far we're on track with DOF. Once DOF does, house numbers will be accommodating, and BSA, your numbers will basically stay. We're just going to drop 2 top and bottom, so you'll be good, and that should correct the paperwork issues. So we're in the process of doing that. I've already submitted the revised application to City Planning. They already have received it on their portal, and I just was on the phone early this afternoon with them, and they have not only got the documents, acknowledged that they received everything that they need, and now I have to wait for them to conduct their review, which, in city planning terms is always a 45 to 60 day. So that's what the city planning has told me today. But this is all straightforward certifications, ministerial, and that's unfortunately what I have to go through with city planning. But now, if we do get acceptance to this, that'll clear the major hurdle for city planning, which is the road is accepted, and then they will proceed to move their application forward. So
I have a question about that, because as you say, the subdivision approval is where city planning looks at compliance with setbacks and so on. So can we get from them, and I guess this is where also Mr. Lobel fits into the story, maybe, I'm not sure. Can we get from city planning some kind of blessing that the houses laid out are compliant?
Madam Chair, I would love for that cooperation to occur. I will tell you that it is not likely, unfortunately. I have a very good rapport with city planning. I've been following with them for now close to 40 years, and with many different, groups and people who are in charge. And the way the system operates now with the online portal, they have, triggers that they move, and they have little less personnel there. I just got off the phone, like I told you, with city planning right before this hearing, addressing that very same issue. And they said to me, everything's good, we submitted, we're all going to move forward. But that's the time frame I have. So to answer your question a little more clearly, in the South Richmond district regulations, what they've done is city planning has created text that clearly illustrates what those requirements are. So they're not a mystery. They're in the text. They've been used since the South Richmond district regulations were established in 1974, and various amendments have occurred. But the data on that is, in an R3X zone, you need a minimum 40-foot lot width. You need to have an area of 3,800 square feet minimum to meet the district requirements. Yard setbacks in South Richmond go by the height of the building. So therefore, in our case, we would have 5 and 10 feet would be the yards, and a 30-foot rear yard. There's an 18-foot front yard. So all of that has been met. With the reduction in the lots, we know we exceed that. We have a 50-foot minimum width. We have an area that's in excess. I have a whole chart. I gave the board all the new documents. And, they're in excess of like 6,000 square feet. And with that, we maintain all the yards that are required. Actually, we exceed the yards. We have no yard less than 8 feet. So we have increased the yards to correspond with the size of the homes and the context with which they're being built within. So we're not looking to jam this thing up. We've created enough spacing between the buildings to be consistent with buildings that are built on 50-foot lots. So literally the city planning can, the text or the board can feel confident in the fact that the zoning text is what city planning must look at, that it's not an individual discretionary issue. It's from a chart in their text that is already usable by the public and the applicants.
Why is there a certification then if all you have to do is comply with the zoning? I don't get it.
Well, that's then there, believe it or not, there is actually in other districts, and I'll say this to you, and it's kind of laughable. They have in natural area an authorization that no authorization is required. So you literally would file with them and they would review it for the fact that you don't have to file with them.
That's the seed in catch 22 about major. Okay, we can move on.
Okay, all right. Having said all of that, I'd like to address a couple of sidewalk issues. Hopefully that can lend some clarification. We have provided the sidewalk on one side of that roadway where the parking can be placed. Unfortunately, lot 60 has a fence around their property, and the fence extends right to the edge of their property. And so this sidewalk would terminate at the beginning of lot 60. There is no sidewalk fronting lot 60. So there's no way that we could impose upon creating a sidewalk in front of that house. So we could do it all around the whole development. I can do it in all the areas that can be controlled, except for in that particular lot. That's the way the approval was granted in the originally. This was also granted as well. The board just looked at the general city law back in the day in 1983, but we cannot change that particular condition. I can make it as best as possible, everything that I can control, and I've done that. And it is shown clearly on the plan. You made reference to, you didn't see that. But if you look at Bsa Drawing 104, I created that drawing specifically for the purposes of being able to show you the portion of the existing Santina Drive and what we had done as a commentary to respond to your commentary. And what it does show is that the roadway is widened. It clearly indicates, it shows the sidewalk, the trees are placed on that area to reflect that. And it also indicates clearly that the parking, which is what is existing today on the west side of Santina Drive, now will be able to be done legally. And that particular length comes to 14 cars. So there is 14 cars that can be parked in the street.
So my question had more to do with this. I see, so I'm looking at a combination of the fire department drawing where you show where you can park on Santina, and then on your BSA set. So so my question was this: the sidewalk that you introduced in the widened portion, which that's great that you widened it to be a reasonable roadway width. That sidewalk, I hope, because it's not clear, for instance, on the fire department drawing that it's doing that. I hope that it joins up with the sidewalk that's on what you call Santina Drive. I guess we should have a different name, Santina Drive version 3 or something like that.
Proposed is probably.
Yeah, proposed Santina Drive, so that So it's not completely clear on the drawings that the sidewalk joins up so that nobody has to go into the street in order to get to the next sidewalk.
No,
my
no, it's
question-
connected. It's connected, absolutely connected.
Okay, so can you give us a little zero in on that so it's clear that they're connected? You know,
Absolutely, unfortunately. Mhm.
you don't have to do it now, but when on a revised drawing, just do a pull-out detail to show that the two sidewalks are connected.
What I would love to do, and I think will solve this problem quite clearly, is if I could actually move away from the 11:17 format and give you a 24:36, since we're living in the digital world, then it won't make any difference to you. I could send that to you in 20 minutes because I already have that drawing done, because that's the drawing I sent to city planning, and that drawing will show you that it is connected. But I will, pending that, I would ask you to believe me when you'll get the proof that it's connected.
Yeah, no, I believe you that it's connected. We need a drawing because nothing like drawings to prove
I'll be
life.
happy to submit that to you. I just don't want that to delay in moving the
no.
project forward.
No, it's not about delaying and moving the project because there's others, the HOA is the issue and so on. But the other thing is, so now having gotten past that, what my comment about the width of existing Santina is, so now you've got pedestrians coming across New Santina Drive. They come into the roundabout, they're walking on a sidewalk, and then they get dropped into the street. So now you have people pushing baby carriages, little kids on little tricycle-y things, trying to get to Arbutus to go to the park or something like that, right? And so I don't get why there doesn't remain a protective zone, which is not on Lot 60's property, that's their property, right? But rather than using Old Santina as a parking lane, you create a 4-foot wide not a sidewalk, but like a protective route that's striped, which is essentially a pedestrian way, which we've used on like restaurants. We have that in places where there's sort of no sidewalks, but we want to make it clear that this is a pedestrian zone and that there's no parking on it. So that's the thing, is that length, that's 232 feet long. That's a long walk to walk in the middle of the street. And what you're suggesting with parking on that side is really walking in the middle of the street, because the cars will be there. And now the kids and the bicycles and all that stuff are walking right as the cars are coming at you.
Well,
So
I would say to you, I mean, unfortunately, we can't have it both ways. So what we did is we set out with the reduction. I appealed to the fire department, had lengthy discussions with them, and they were satisfied because that all emergency services and fire department access was rectified, and was the proper widths were given to them in a clear path. So having said that, it opened the door to the parking in front of Lot 60, which was a big concern of yours at the last hearing. So I've given that the concentration that it's no longer restricted. It's parking is able to be placed there. It is my opinion, based on the distance and the amount of spots, the excess spots that I provided for the new developed homes, that unless you're having a massive, once a year party, that those people that are in the new development are not going to be parking in front of Lot 60. Lot 60 is going to be having their own people park in front of there, which was one of the concerns that you had about having this individual not have what they were normally accustomed to. And I understand, and I've given that. But if we're going to create like a bike lane, so to speak, a bike lane pathway, then I would have to give up that parking. And if I gave up that parking, which one is more critical to the, to the board?
Oh, no. So then that was the second part of the question was, it's great that you widened that little sort of angular portion that brings it into the roundabout. And the reason you were able to do that is because you control the real estate on either side of that roadway. Yes. And so my conversation last time was, there's this really strange shape. It's like the outside of the keyhole, sort of. And the discussion was about making that a parking zone rather than a nothing zone. And not that nothing
Well,
like trees.
it's not a nothing zone here's where South Richmond's regulations actually kick in. There are
Okay.
trees there. And those trees are protected under the South Richmond District regulations. And those trees also apply to the tree credit requirements for those existing lots.
For the
So,
existing lots.
yes. So I've met on my new development, I meet all my tree requirements, 1 per 1,000 square feet. And on these lots, with the exception of lot 60, these other lots, they also meet those requirements. And there is a whole series of trees, which on BSA drawing 104, I've shown you where those trees are, which match the survey. So when I widened the roadway, I purposely widened the roadway looking at the drawing on the right-hand side, because that permitted me to do the widening without killing 3 trees on the left-hand side. So I saved the trees, gave you the sidewalk, gave you the parking, and, managed to, with a lot of effort, make this whole thing, work together as a whole.
Okay, I was unaware of the tree preservation requirement. So that's why, because when we discussed it the last time, that didn't come up. And, because you said you would look into finding parking, so that didn't come up. Okay, understood. Thank you.
So I think based upon, the trade-off situation, as probably leaving the parking requirement there, what I don't see is I don't see 14 cars coming for lot 60 on a regular basis. And I think the likelihood is that the discharge from the sidewalk we're going to install would actually be able to work along that curb, and in most instances would not pose a problem for the strollers and as such. The tricycles I think are going to be really relegated. If I have 2 boys, they're not tricycle age anymore now. But the point is that in the new developed section, we have sidewalks on both sides of the street. And I think the parents will probably keep the tricycles in front of their home where they can monitor it a little more clearly. And so I don't think it to be a significant issue based on that we have other options or other places for that to happen.
Okay. You've answered my question about why that doesn't become parking. I don't necessarily feel this way about kids running in the middle of the roadway, no matter what. But and I was watching, like on Arbutus, you see kids playing, but they're playing on the side, right on the shoulder. It's not actually a sidewalk; it's like a grassy shoulder. But this doesn't even have that. That's a problem with all of these grants that allow for building. This is the famous house behind a house problem, where the front facing house has no width and no side yards effectively, right? So then you put a very narrow roadway. This is not anything to do with you. This is a earlier approval, and there you are with this landlocked piece of property behind it. So, okay. Okay, thank you. I appreciate the thoroughness of your analysis. So you can continue if you have more you want to add.
I think hopefully, we talked about the HOA issues, and we'll be straightening out all of those documents. And I was hoping to be able to, present to you with that being said, that the hearings could be closed so we can leave the public record open so that I can get all the paperwork and these other documents to you in the proper time frame.
That's potentially doable. I don't know. Tony, you have something you want to say?
I had asked whether you wanted DOT and DEP to look at the revised proposal. Do you not want
Right.
that now?
No, of course we want that. It's not a
So,
seeker review though. You know, the
not a
reason I'm,
seeker review. I mean, do you want anything later on from CPC?
so,
So I just want to cover all the
Right, so-
bases.
yeah, no, when, in terms of being willing to close, we can't close when we have open seeker. That's not permitted,
Right.
right? Or open landmarks or something like that.
But this is non-seeker. Non-seeker.
Seeker, these are us trying to get clarity from these agencies if we left anything out, right? So we plan on sending this to DOT, right?
DOT and DEP as we normally would a GCL, but now the project is revised. So we would send them the revised project.
Right, so that's all. So because I am sympathetic to how long this has been going on and how long it's taken to get to a place where Mr. Khan has done, I have to say, an excellent job. And in persuading all of the commissioners, but I have to say, me especially, that this is the right density and that all of the issues are being taken care of. So we do have kind of a lot of open issues, but I don't see why they couldn't be handled post-closing. Yeah, Commissioner Shetta, go ahead.
Yeah, I just wanted to ask them to add the note I mentioned during my testimony to the drawing titled Plan Showing Proposed Storm and Sanitary Drainage for Property. The note did say that DOB has to review the calculations for the dry well and the sewer system.
We will get, sir, we will get an SD 1 and 2 that will verify that to your satisfaction.
Thank you.
Okay. All right. So let's go to the public, see if there's anyone who would like to speak on this application first.
The application we are currently discussing is 2018-68A through 2018-90A. This is Santina Drive for development in Staten Island. If you wish to call in, it is 646-558-8656. Webinar ID number is 997-3548-2603. And if you need the passcode, it is 564549. And if you wish to call, when you call in to speak, you can press *9 to raise your hand and *6 to unmute. If you're in the Zoom room already, please press *9 to raise your hand to speak.
Okay, so one thing I do want to pick up about the maintenance commitments and so on, and maybe this is Mr. Lobel's domain now. He's been sitting there so patiently and silently. That in terms of the 2/3 majority, so to amend the restrictive decks or HOA, to make it clear that it's the 2/3 majority that has responsibility for complying with all the terms, all the conditions. So maintenance, development, insurance, what do you call it? Performance guarantee of some form. All those two, by the way, in favor of Department of Transportation. All of that is the 2/3 majority, lot 60 being taken out of it. Okay. I just want to make sure that that's done. That's important. And I don't want to be having a conversation about it where we have to open the hearing again. So I just want to make sure that all of the things that I mentioned are going to be done so that if we don't receive them, I don't want to have to reopen the hearing. That's the reason when we close, because we won't have to reopen.
Yeah, assuming that Mr. Santa has no objection, while we're not the council that prepared the HOA, we're happy to usher through the revisions and to get those back to BSA council for review.
Okay.
Mike, is that?
Yes.
Okay.
All right, so the back and forth will be with our council. So when council makes corrections, that's what will be done. And that should be done constantly. So in other words, don't wait for us the submission deadline. get going with it right away now that you know the sort of the terms of the deal,
Yeah.
right? Okay, all right then. Do commissioners have any, oh, I want to ask our counsel. Kurt, are you okay with us closing this?
Yes.
Okay, all right. So then, how much time to respond to all of this?
Actually, on my end, and for probably with, I don't know how long the council would take to go back and forth, but I know with that, I'd say 3 months.
Okay, that makes sense to me. Okay. Excellent. All right, so just to putting that in perspective, that puts you on for a decision like in September, right? Okay. All right then, excellent. So thank you, everyone. I'd like to make a motion to close.
Thank you.
This has been a hard fought case. And I'd like to compliment Mr. Sana on a really excellent job.
Thank you.
Chair Perlmutter?
Aye.
On the motion to close, Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shepherd?
Aye.
Commissioner Shabeta?
Aye.
Thank you. We'll let you know the date, Mr. Sana.
I'll let you know the hearing date, but I'm guessing it'll be the September hearing.
Thank you very much, commissioners.
And any feedback, Mr. Sana, I will forward to you, and then you can respond to interagency.
Thank you.
Item number 20, 2018-178A, 2 Oak Tree Way, Staten Island. You saw my email, Madam Chair?
Yeah, so this one, the applicant isn't available today. He has a family emergency. We don't know whether the emergency will continue until tomorrow, but, or whether he'll be able to be available, not that the emergency will have been eliminated. But I'd like to put it on for second call for tomorrow to give him an opportunity to participate in the hearing. And hopefully we'll have time to handle it. Okay. Right,
Okay.
Tony?
Okay, do you want to do you know when you want to do it? Morning, afternoon?
We're going to, so I don't know, but if we can talk about whether we can talk about an I don't know. Let's find out from him whether he might be able to attend some part of the morning
Sure,
session.
sure. Okay,
Because the afternoon, I don't know whether that's going to be a long hearing. We don't have a lot of cases, but potentially the hearing will be long. So, so yeah, so let's find out from Mr. Rampula.
okay, where
he
is that?
Let's ask him tomorrow morning what he thinks. That's all. I'm just trying to be sympathetic to his, you know, let's say unexpected situation.
Yeah.
Okay.
Okay, so since we're going to second call that case, so this concludes the public hearing for May 10th, 2021, 2 p.m. session. We will resume tomorrow at 10 a.m. with a new calendar.
Thank you, everyone. Have a good rest.